A very good morning, everyone. I am CS Kajlande from Nyandeep Academy, and today we will be talking about the Hindu analysis dated 10th of January 2025. Okay, so these are the four news that we will be covering today. Interesting, and if I talk about today's newspaper, it is more of a general read. Okay, and these are the main topics from exam point of view that we need to know. So the first one, we'll be talking about the same-sex marriage. Number two, we will be talking about rights of persons with disabilities. Then we will be talking about the BNS. I have been again and again telling you all that BNS, the new law that a home minister has brought up, is very important. There are 100% chances of questions being asked on BNS. So whichever attempt you are giving, BNS is important, and whatever news about BNS is coming up, it has to be covered. And next we will be talking about dual citizenship. So today's topics are more important from mains perspective, mains point of view. So the first news is Supreme Court rejects the review of judgment. Okay, now what exactly happened? Supreme Court, there was this 5 judges that were there in the Supreme Court panel. It was headed by Justice Gavai. They rejected petitions. There were certain petitions that were saying that a decision was passed last year, 2023 October. A judgment was passed which said that same-sex marriages are not legal. Okay, we cannot legalize them, the same-sex marriages. This decision was passed in 2023 October. Now, there are reviews against this judgment, that please review your judgment, that if it is right or wrong, and think about it, try changing your mind. This is what the petitions were there. But Supreme Court rejected these petitions. What does that mean? That this judgment, which does not legalize these types of marriages, this judgment will stand correct. It will stand solid. Okay. Now, they said that we have carefully gone through the judgments that were delivered by Ravindra Bhatt, Hema Kohli, as well as Narsimha. Okay, these were the judges. They had delivered this judgment. They said there was a majority of the panel said that this cannot be legalized, and also right now they did not find any error while reviewing it. Now what is exactly a same-sex marriage? It means legal and social recognition of marriage between individuals who are of the same gender, like a male and a male getting married to each other, or a female and a female getting married to each other. Okay, now they're getting married to each other, and they are expected that they will get the same rights as when a male and a female get married, like the normal marriages. Okay, so they want the same rights, they want the same societal status. Okay, this is what the entire case was going all about. Okay, especially legal rights and same responsibilities. They are demanding legal rights. If same-sex marriages are legalized, so obviously the normal couple, like a male and a female, the way these people get rights, similar way mein, that couple will also get the rights legally. Okay, like the property can be passed on, they can adopt a child, etc., etc. There are many such rights. So, the Constitution bench, according to a 3:2 verdict, that is majority, they said that we cannot give same-sex marriages constitutional validity. As per Constitution, we cannot say that, okay, this is valid. Also, the Chief Justice of India said that the court can neither strike down or add words into the Special Marriage Act, that is SMA. Now, what is SMA? Special Marriage Act. It is a law, it is an act, it's a secular act that governs the marriages in India. Okay, now this act does not talk about same-sex marriages. So the court said that we cannot change any law. If a law is supposed to be changed, that is the work of parliament, that is the work of legislature. Judiciary can only interpret law. Okay, so he said that we cannot add words or we cannot delete words from this SMA Act. We cannot include the same-sex marriages here. This is the job of legislature. If the parliament has to change it, they will change it. Okay. Also, it said that the right to marry is not expressly recognized either as a fundamental or constitutional right, but it is just a statutory right. Okay, so in the constitution, it's not specifically written that right to marriage is a fundamental right, but it is a statutory right, like law gives you that right to get married, but you cannot change or you cannot question constitution on this particular thing. Okay, moving on. Now, there are in certain case laws, there are instances where we feel that marriage is as important, it is a part of fundamental right. There are certain instances. Now, let's see where. If we talk about Article 16 of Universal Declaration of Human Rights, वो time पे the Supreme Court said that the right to marry is one person's own choice. Okay, like if that person is an adult, he has the right, she has the right to get married. And this right, it is important as per Article 21. Now, what is Article 21? Liberty, right? Personal choices, liberty. So, even this right comes under that itself, because it's a personal choice. That individual needs to have the freedom to get married. After which, the LGBT community, they have been given all the constitutional rights, okay, as per the 2018 case. The Supreme Court held that whoever are the members of LGBTQ community. Now, what is LGBT? LGBT stands for lesbian, gay, bisexual, transgender and queer. So, this community have been given all the rights which are given to other citizens, especially if we talk about fundamental rights, okay, and their liberties are supposed to be protected by the constitution, just like the way a normal person's liberty is protected, the way he receives right, everything should be done to them. They need to have equal citizenship, they need equal protection of law. So even as per this, if we talk about, there are certain instances where we can say that marriages is a personal choice which needs to be protected. Now that we are giving all the constitutional rights to LGBTQ, India is appreciated a lot on international level, diaspora. India, because when India gave rights to LGBTQ, it was one of the rare countries to do that, to give constitutional rights, to give representations in various government bodies. So India was one of the few countries to recognize that. Okay, so which is a very, very big decision. And on international diaspora, India is appreciated a lot regarding this particular matter. So under all these instances, there are reviews being filed now that it's high time. Same-sex marriages should also be made legal. But as of now, the Supreme Court has rejected such a petition. Now let's see what happens further. Okay, now if we talk about the Special Marriage Act, as I said, it is applicable for the entire country. There are personal laws also. If we talk about Hindu Marriage Act, Muslim Personal Law Application Act, so there are various personal laws even that are covered under this SMA. Now it is the duty of judiciary. You need to ensure the rights of the female and the male, both are protected, the husband and wife. Also, if we talk about SMA, they have provisions for civil marriage for people of India and all the Indian nationals who do not reside in India, who reside in foreign countries. We do not care what religion they follow, what customs are they following, but just because they are Indian nationals, they will be covered under this particular act. Okay. Now, under this law, whenever a person, under this specific law, whenever a person is getting married, so the personal law will not be followed, SMA Act will be followed. So this was about the first news. The second we will be talking about is India open to the idea of dual citizenship. Very, very important from exam point of view, mains perspective. You'll need to know what dual citizenship is. Okay, let's move on. Now, citizenship. If we talk about citizenship, part 2 deals with the citizenship, part 2 of Indian Constitution. Article 5 says that a person who is a citizen of India It can be either by birth, it can be either by his parents being Indians, it can be either by acquiring it or having remained a resident after being a resident of India. Okay, so these are the various ways in which a person can be citizen as per the Indian constitution. Now, being a citizen and being a domicile are two different things. Domicile is different, citizen is different. Domicile means someone who's staying in India. Okay, but he's not a citizen of India. Someone who stays domiciled, but he's not a citizen. Like there are many celebrities, even in a Bollywood, okay, who stay in India, but they are not Indian citizens. They do not have the citizenship. Now, this was determined by the Supreme Court in DP Joshi versus State of Madhya Bharat. This is a case law. If you guys can remember the case law well and good, you all can quote it while writing your answers. Even if you all don't, it's fine. Not a big problem. Okay, so the only main amendment that has come up to Citizenship Act was that there was a fast track process. There were minorities from the neighboring areas, the minorities that needed refuge in our country. So for them to acquire citizenship, we had a fast track process. Okay. Okay. Now, if we talk about, like dual citizenship. Now, what is exactly dual citizenship? First, I'll explain you all what is dual citizenship. Okay. See, dual citizenship matlab you have more than one citizenship. Okay. Grants an individual legal status as a citizen of two or more countries at the same time. So we can be a citizen of US and at the same time we can be a citizen of Israel, for example. Okay. So we are citizens of two countries at the same time. Now, is India ready for something like this? Now, if that question is asked to you, what would your mindset be? Are we ready to give dual citizenship to our citizens? Or do we want exclusivity in this? We want that Indian citizenship, if that person has it, he cannot take any other citizenship. Right now, that is the rule. Okay, right now we don't give dual citizenship. India is not a part of it. But are we ready even in the near future? I feel no. Seeing our neighbors, seeing the hostile environment that the world is living in, seeing the rage of wars that have been happening, I don't really think India is ready for dual citizenship. Okay, but anyways, let's see. So, which are the countries that are offering dual citizenship, that you can be a citizen of this country as well as if you want to take citizenship of another country, you can. That is US, Finland, Albania, Israel and Pakistan. These are few of the famous names. Indian constitution, as I said, it does not allow, it prohibits dual citizenship. Okay. Now, if we talk about as an Indian citizen, in the editorial, they say it is difficult, dual citizenship because it means undivided loyalties. Because after all, you have a citizenship of two countries. So your loyalty is going to be towards both the countries, okay? And which is very risky in such an environment, divided loyalties. Now, there are situations where people have decided to make India their home. They have relinquished their earlier citizenship and become citizens of India. That is fine. That earlier citizenship is being relinquished. It's being given away, cancelled, and now you are a citizen completely of India. That is okay. But at the same time, being citizen of India and some other country is a bit risky, dangerous. Now, if we talk about Mira Alfaza, she is known as the mother. Her work was inspired by many. She also founded the Aurobindo Ashram. She became an Indian citizenship. Earlier, she was also campaigning for dual citizenship, but later on, she gave up her previous one and she became an Indian. Then, if we talk about Mother Teresa, everybody knows who Mother Teresa is, right? Mother Teresa wasn't an Indian citizen, but she later on became an Indian citizen. Then if we talk about Jean Dreze, he's a very famous economist. He was a Belgian, he had a Belgian background, a European background. He gave it away. He gave that and he became an Indian citizen. Now here if you saw all the cases, these people had to give away their previous citizenship And then these people had to give away their citizenship, and then they got accepted as an Indian citizen. Correct? So that is allowed, that is okay. You are giving away one and you're having an Indian citizenship. The rule is, as per our constitution, when you have an Indian citizenship, you are not supposed to have any other country's citizenship. As simple as that. Okay? So at a time, you cannot simultaneously be an Indian citizen as well as somewhere else. But this is allowed in the names of the countries we saw, US, Israel, Pakistan, etc. This is allowed there, not in India. I hope you all have got the difference. Once again, relinquish करने के बाद, if you're being an Indian citizen, it's okay. But you have the citizenship of previous country and then you want Indian citizenship also, that is not possible. Okay, now if we talk about US, we feel that our US is so broad-minded, is so flexible. But if we talk about US, you cannot become a president there, however powerful you are. You cannot become the president there until and unless you're not born in the territory. So even if you acquire the citizenship of USA, you cannot become a president there. Now, let's talk, for example, we'll talk about Elon Musk. Now, Elon Musk, I think he's right now today the most famous personality in the entire world. Elon Musk, so powerful, so rich, so famous, he still cannot be the president. Why? Because he is not born in America. He was born in South Africa. Okay, so this is the law, this is the rule there. So, however, we feel that America is very flexible and broad minded, but they do have certain strict regulations even there. Okay. Next, we will be talking about persons with disabilities. So, the Supreme Court, they have held that there is a new set of rules, rights of persons with disability rules 2017. Now, these are contradicting with the original act of 2016. Okay. Now, how? The court said that the rule was drafted in a discretionary tone. Discretionary as in, you can do it if you want to. Okay, it wasn't made compulsory. But if we talk about the act, the previous 2016 act, they had mandatory compulsory obligations on certain institutions and government. But 2017 rules, they are making it sound very optional. Okay. Now, if we talk about Rule 15, it was a statutory provision under which accessibility guidelines at the respective departments should give accessibility to the persons with disability. Okay, all that was written. Like, for example, if we talk about Ministry of Housing and Urban Development, this ministry, they were given guidelines that they should create a barrier-free environment. The Road Transport and Highways Ministry was given a guideline to make things easier for persons with disability. Okay, but later on, all of this became optional as per the rules in 2017. The court also said that rules 2017 are giving an option to the ministries and departments, which is not correct because the act had made it compulsory. So these two are contradicting each other. Also, they said if you are knocking down certain rules, certain guidelines, as a result, the government might, or any authorities might not follow the procedure that had been previously made compulsory. But of course, right now the government has been given 3 months that whatever the basic accessibility requirements for the persons with disabilities are, let's create at least the basic ones. They have been given 3 months for this. Okay, now if we talk about Canada, even Canada has developed a roadmap. They are saying that by 2040, there will be full accessibility to persons with disabilities, PWDs, I'm going to call that. They are focusing that let's come together, let's harmonize everything, and the way it is for normal people, let's provide the same accessibility, similar information, broadcasting, highways, in all fields, in all streams. Let's provide the similar environment to PWDs. Okay, so if we talk about the act, they were talking about barriers, that PWDs face many barriers But as the time passes by, we need to create accessibility for them. We need to remove the barriers for them. There are infrastructure barriers, there are digital barriers. All of these need to be worked on. Time and again, social audits should be taken place, that if the central government, if the state government, they are following schemes, they are coming up with programs that are important for this category of people. Also, if we talk about social audit will increase the accountability of the government. The government will be answerable, that what have you been doing for our PWDs? What infrastructure changes have you made? What broadcasting and telecommunication changes have you made? The social audit we can ask them all these questions, okay? Also, the main thing is technologies should be developed a lot more, because ultimately technology is the one which is going to help them the most. So with the help of technology, advancements should be done in the entire country. And last topic for today, Section 152 of BNS should not become a proxy for sedition. So first I'll explain you what is sedition. Okay, now sedition means any act or an attempt to bring hatred towards the government that is established by law in India, or to incite disaffection or resistance against it. Okay, so you can call this sedition is something that is that you are spreading hatred. You are not happy with the current government, so you are spreading hatred against this government, or you are creating a propaganda against this government. So all this comes under sedition. Okay, so the Rajasthan High Court, they said that this section 152 cannot be, used as a tool. In 2022, before the BNS came into picture, Supreme Court had suspended the pending trials that were going on of IPC until the government reconsidered the law. Okay, so there were trials that were going on under this case, criminal as well as whatever the court proceedings are going on. So the Supreme Court had suspended them, after which the sedition term, it came into existence, and it was said that this term would be repealed, and section 152 of BNS, the word is not used, okay? Now the sedition word, which was previously used in IPC, in BNS this word is not used, but section 152 says that BNS, that if there is any activity that can lead to people taking up guns and arms and ammunitions and coming against the government, or cessation, like a part of Indian territory going away, or we are doing any subversive activities, anything that is working against the country. If any such activity is being done, this person will be charged under criminal offense. This is what section 152 says. It does not mention the term sedition, which was previously there in IPC, but this is what section 152 says. Now there is a fear that these two shouldn't, like, though we have repealed the word sedition, but 152 section is very much similar to that. So this shouldn't just be a cut, copy, paste of sedition. Okay, this is what the concern is in this news. Also, section 152, it will criminalize any act if we are encouraging feelings that we should get separated from India, or we are hampering the unity, the integrity, the sovereignty of India. Any such act will lead to criminal charges. Okay. The BNS does not use the term sedition, as I said, but the High Court's recent decision says that it is very much similar to what sedition in IPC was. First of all, section 152 of BNS, it criminalizes any such act. Also, any specific term is not been defined here. So this provision is kind of vague. It might be confusing, and it is left to the interpretation of the enforcement authorities, which might later on be a bit dangerous for the freedom of expression, right? Because if clear-cut proper definitions are given, we know what is what. But here, when clear-cut definitions are not given, people can interpret freely whatever they want. As per their convenience, they will interpret law. This is something that can go against freedom of expression. Now, if we talk about people that are arrested between 2015 and 2020, there are 548 people arrested for sedition, but only 12 people were the ones who were given punishment, who were convicted. Okay, if we talk about in the past, judiciary has always spoken about that there should be a balance. Okay, now balance between what? Freedom of expression, you can say whatever you want, and national interest. Just under the name of national interest, you cannot curb someone to talk about their opinion. Okay, and also under freedom of expression, that we can give whatever opinion we want, that shouldn't hamper the unity and integrity of our country. So there should be a balance. Okay, if casual slogans are coming up, so it's okay, you cannot term this as sedition directly. Okay, if there are major consequences, major repercussions after this, okay, we can think about it. We need to see what is the impact of this particular action, if we need to term it as a sedition. Also, the court had differentiated that there is a difference between disloyalty towards the government and criticizing the government. Everybody has the right to criticize the government if they feel that this is something that is not going right. Okay, but that doesn't mean that this particular person is disloyal to the government. The liberal space should be provided for everyone to put up their thoughts, to put up their beliefs, to express whatever they want. That should be done, but at the same time, this shouldn't go against the national interest. Okay, so if we talk about section 124A, this was the one that was talking about sedition. It was a non-bailable offense. A person who was charged with sedition can never become a government employee. They have to live without their passport always. Also, they can be punished with life imprisonment or fine, or at least 3 years and a fine, or just a fine. Depends on the impact that the sedition has had. So this was the IPC section, and right now we have a similar section in BNS, that is 152. Okay, so yes guys, that's it for the day. As I said, much of this was important from your mains perspective. Please remember all these points, and please try to put on your opinions connecting to the facts. Okay, so yes guys, that's it. We'll stop for the day. I will see you all tomorrow for the next Hindu analysis. Thank you so much.